IFA-India Academy has been conducting monthly webcasts on the current topics of interest on the subject. The last one was on the India-Mauritius Protocol. Today's discussion is on one of the important aspects of interpretation of tax treaties, which has raised a good deal of controversy, especially between the Indian taxpayer and the Indian tax administration. This is on the use of phrase may be taxed in tax treaties and the taxation rights of resident state in respect of such income. To conduct today's discussion, we have two expert panelists, Mr. Kamlesh Varshney and Mr. Ajay Vohra. I am Vijay Goel, Chartered Accountant, and would be a moderator. To introduce the expert panelist, Mr. Kamlesh Varshney. He is a Commissioner of Income Tax, International Taxation, New Delhi. Mr. Varshney has been in tax administration for a long time and has been involved, especially international taxation administration, in various capacities. Mr. Vohra, he is a senior advocate and is an expert dealing in international taxation. He has argued various landmark cases before the Honorable Supreme Court and various high courts in India.
Section 90, subsection 1 of the Income Tax Act provides for entering into agreements for relief and avoidance. There are other aspects also, but these are the two relevant for our discussion. Is there any difference between the two terms?
Yes, I think there is difference in the two terms, because when tax treaty says avoidance, it would mean that it would get taxed only in one contracting state, and the other contracting state would not tax that income. And when the purpose of the tax treaty is to provide relief, then both the contracting states will tax the same income, but one of the contracting states, that is the resident country, will allow relief to the extent of tax paid in the other contracting states. So therefore, tax treaty can provide for, can avoid double taxation or can eliminate double taxation either by relief or by avoidance.
So what is your view, Mr. Vohra, on this?
I agree. I think if you look at the relevant article in a treaty, that will talk of elimination of double taxation by either of these methods.
Yes.
So it is up to the contracting states how they agree to eliminate double taxation.
So this is in the context of the credit method and exemption method as propounded by OECD.
Yeah, so that is one aspect which is relevant for maybe tax phrase, but there is also another aspect for shall be tax. So when it is shall be tax, in that case one contracting states get the right to tax it and the other contracting state shall not tax it. So in that case they will avoid taxing it. So they will eliminate double taxation by that. And the two methods that you are talking about, credit method and exemption method, that would be relevant when both the contracting states are taxing it. Then how the other contracting state will eliminate double taxation would be determined by the article on elimination of double taxation. Like India follow credit system, so India generally goes for relief, but there are other countries who follow exemption method. So within the same tax treaty you may have, like India will have with some developed country, that India is following credit method for giving for eliminating double taxation, but the other contracting state is following exemption method, which is avoidance for eliminating double taxation.
Right. I think we will have another question on the shall be taxable also and try to see where is the difference in this. So presently the question moves to the second one, which is on section 5. Section 5, which deals with the scope of total income in case of a resident, includes all income from whatever source derived, which as per clause C of subsection 1 accrues or arises to him outside India during such year. Considering that India has residence-based taxation over the worldwide income of its residents, can there be an intention of the legislature that India would, by an agreement under section 90, subsection 1, cede its right to the other country to include an income in the scope as per section 5 subsection 1?
Yes, it can happen because if you see, generally the avoidance is only with respect to non-resident source based income. So if a non-resident is earning an income, let's say we are the source country, and if he is earning income in India, then generally treaty will put down rules that when will India have right to tax it. But it can happen in some of the articles that even resident country can let go its right under the treaty. So for example, Article 8 is on transportation by shipping or air transportation. There, the OECD Model Convention talks about place of effective management. Now some of our treaties also have used, although we are not member of OECD, but some of our Indian treaties in Article 8 have also used place of effective management. That means where the place of effective management is located, that country has a right to tax it. And only that country has a right, not the other country. So for example, an Indian shipping company or Indian air company, suppose he has a place of effective management in another country, and then he becomes, then that country will have the right to tax it. So, it can happen only also for resident countries. Same is like government servant, when, like suppose if I go and on deputation to a foreign government, and if I earn an income over there. Now, the model tax convention is, which you will find in most of our tax treaty also, that only that country who is paying me, the government of that country who is paying me, has a right to tax. I may be resident in my country because I may have spent only a few days in that overseas territory, but still only that country has a right to tax. So India has to eliminate double taxation by not taxing it. So generally, resident country have a full right to tax it under the treaty, but there may be some situations like what I have narrated, that even resident country will have to forgo their rights under the treaty.
I think Vijay, I'll just add, if you look at the opening words of section 5, it says subject to the provisions of the Act. So while the source rule in section 5 defines how income needs to be taxed for a resident or a non-resident, it is subject to other provisions of the Act. And double tax treaties are entered into under section 90 of our Act. So section 5 will be subject to section 90. So if there are beneficial provisions in section 90 or in a double tax treaty, they will override the provisions of section 5. So you may have a situation that notwithstanding resident-based taxation under section 5(1), the income may not suffer tax in India, where it is subject to tax in any other jurisdiction because of the wording of the double tax treaty.
So is this only in the Indian case scenario or the world over the same practice is followed?
The same practice, all right.
So I think this takes us to the other question, which is the use of similar phrases which are there, and these have always been a challenge to distinguish. The controversies have come up on that, and the different treatments are being interpreted for that. So the following phrases are used in the distributive rules: A, may be taxed; B, may also be taxed; C, shall be taxed; D, shall also be taxable; and E, shall be taxable only. So what is the difference when using these terms?
There are two categories of, first we need to understand the difference between two categories of phrases, shall be taxed and may be taxed. So when we use the word shall be taxed, it means the income will get taxed in that contracting state, which has got the right under the tax treaty. And then the other country will not tax it. This is general interpretation. And may be tax means that yes, we are giving a right to the other country, but the first country also has a right to tax it. And how the income is to be double taxation is to be eliminated, that will be determined by the article on elimination of double taxation. This is a general principle to interpret these two terms, may be taxed and shall be taxed. Then there are various other versions that may also be taxed. So it is making more clear that it may be taxed in one country, may also be taxed in another country. Then shall also be taxed is the same meaning. It is probably taking away the meaning of shall be taxed. When it says shall be taxed in one country and shall also be taxed in another country, probably it will get taxed in both the countries. And then again we will have to go to article on elimination of double taxation to decide how to eliminate double taxation. Shall be taxable only I mean, in my view, I don't know, probably Mr. Vohra can speak on that. In my view, I don't think there is any difference between shall be tax and shall be tax only. But there is an Australian court judgment where they have said that because the word only is missing, so that way it will get taxed in both the countries. But I mean, my views are different. In my view, they probably mean the same thing.
I, sir, was going through a treaty on, especially Article 7. It says, shall be taxed only. And now this gives the right to the source country to tax it. It's almost like an exclusive right. But then the caveat it added, unless the enterprise has a permanent establishment in the other contracting state. So, shall be taxed only is giving exclusive right to the source country. But if the caveat intercedes, if there is a permanent establishment in the other state, then the other state has a right to tax. So the source country will get a right to tax. So I can do no better than read what Professor Goel has said in his book on Double Taxation Convention, where he has explained these assignment rules in the OECD model commentary. And he says, if you permit, I'll just read this. This says certain income shall be taxable only in a particular contracting state. This term is mandatory and preclude the other state from exercising its right to tax. Therefore, the income or capital must be exempted from tax in the other contracting state, and he has given examples of several articles. Then certain income shall be taxable only in the contracting state unless. So this is the caveat that is added. This term provides exclusive primary taxing rights to the first state. However, if certain conditions are met or not met, the same condition income may be taxed in the second state. Then certain income may be taxed in that other state. This term has an enabling rather than a mandatory implication. It gives a state the option or right to tax if it so wishes, without affecting the existing rights of the other contracting state. May be taxed in that other state. Then certain income may be taxed in the other state, but may also be taxed in the first state. This term gives both states the optional right to tax, if they wish. The article may impose limits on source taxation in certain cases. And in one case, the article specifies shall not be taxed. So he has said the phrase shall be taxed, may be taxed, are to be given their ordinary meaning, depending upon the context.
So I think in this context, it's important to look at what OECD commentary says on this. So OECD commentary classifies the rules, distributive rules, under three categories. It says, in one situation, it is the exclusive right to tax. So,
Shall be taxed only.
looks like shall be taxed only. So, but at the same time, it is also mentioned that such exclusive right to tax, as a rule, will be available to the resident state only. This is also mentioned there. And the second one is the limited right, where both can tax, but source state rate is capped, like interest and dividend. So there is a limitation to the rate. That is a limited right to taxation which is given to the source state. And the third is an open right without limit to the source state given, like may be taxed. So we don't know at what rate, how the income will be there. The source state is given a right to tax in an open manner.
So that will be based on the rates in force in the source state.
Right, very right. So meaning the right is not limited, it is not an exclusive right which is there. So the concept which appears to be in the OECD commentary is that whatever the situation may be, available to the resident state only. But in the other cases where the limited right is given or an open right is given, it is possible that both are taxing in that situation. In that situation, how to eliminate? According to the commentary, the elimination is possible only through the elimination article.
Yes.
So that means if we put together all the 3 points in this, it appears that in any case, the exclusive right, whenever is available, that is available in the resident state. So that means there is no need for elimination in that case. Secondly, when the limited right is given or when the open right is given, it has to be routed through the elimination article only. So when we say the may be taxed, can be that to the extent of that you are giving the right to the source state to exempt that income. Whether it is may be taxed, shall be taxed, shall only be taxed. The question comes is, as these Articles 6 to 22 do not appear to be given as per the international practice, a situation where the exemption can be given per se under our distributive articles from 6 to 22. The elimination effect can be taken only through the Article 22 or 23 depending on the treaty. So where is the controversy on this? So why is so that we are considering in various situations, in various judgments, that the maybe tax amounts to exemption, or there are cases where the discussion is there on the shall be tax only. So what is your view on it?
First, moving on to that controversy, let me just first clarify one aspect, which you said that OECD commentary is saying that shall be tax is only with respect to the resident country, giving exclusive right to the resident country. So I will just read out from OECD commentary because there are 4 exceptions to that.
Yes.
So what it says, the word shall be tax only in a contracting state preclude the other contracting state from taxing. Thus double taxation is avoided. The state to which the exclusive right to tax is given is normally the state of which the taxpayer is a resident. But in 4 articles, the exclusive right may be given to the other contracting state of which the taxpayer is not resident. And then it says which are the 4 articles. Article 8, which I spoke about. Then Article 13, bracket 3, which is the capital gain on sale of ship or aircraft. Then Article 19, which is the government service. And then Article 22, once again the capital wealth tax on ships or aircraft. So basically these are the 2 in general. He talks about 4 articles, but they can be clubbed under 2 heads. So he has given example of 2 exceptions. So it is not necessary that it is always a source country which is given the exclusive right. So I will just give that correction. And this, the whole commentary of OECD on this Article 23 has been incorporated in UN commentary also.
Exactly.
And which we are a member of UN, so it is so it is binding on us because it is part of UN commentary also. So that is the first aspect. Then the second aspect is I fully agree with you that Article 6 to 22 they are distributive rules. So basically it will say which country has a right to tax. So sometimes it may be given to only one country, shall be tax, or it may be given to both the country, may be tax. And then we have to go to article on elimination of double taxation. So when we say that when it is shall be tax, then the other country is precluded from tax. But still article on elimination of double taxation sometimes may give us something more than just exempting it. Like India, in all our treaty, whenever we say that only the other contracting state has a right to tax, but we will include it for rate purpose, just like agriculture tax. Like we include agriculture income for rate purpose, it doesn't mean we are taxing agriculture income. But for individual, because they are slab rate, it's not a flat rate of tax. So by including agriculture income, higher rate of tax is applied on the other income. So same treatment is given to shall be tax in Indian treaty. So maybe we have allowed the other country to exclusively tax it, but we will include it in our Indian taxation only to determine rate on other income, but we will not tax it. So this is a general concept.
So when you say exemption, like Varshney is saying, on that exemption is allowed sometimes. So actually we did a small study, and what we found, the strongest wording in favor of the exclusive right going to the source state is shall be taxable only. But out of the around 90 treaties, at least in 50 treaties, we found that this shall be taxable treatment is given. Shall be taxable only treatment is given. So the question before us is whether the tax effect is there or not, whatever the reason may be, can altogether you can exempt from the distributive articles inclusion of that income in the resident state, or it has to be included first and then an exemption is to be claimed. So it has an impact on that. The impact is like when you are not including at all, you are not giving the right to the assessing officer to know whether it has been rightly claimed or not. So by inclusion of that, possibly there is a rationale. That is the reason that 50 treaties out of 90 are giving that it has to be included, and they are using the word exempt also for that. And they are saying that maybe tax can be exempt and shall be taxed when exempt will have this meaning. And the treatment will be like that. So my question is, it is not a question of like say 4 or 5 some casual treaties talking about that which may not have looked into that, we can interpret. It is the majority of the treaties which are talking about in the elimination article shall be tax only treatment which is to be included. So whether it is a case of the progressive taxation or the exclusive right to the resident state to evaluate whether that benefit should go to the person or not.
No, I think basically it will be helpful if we illustrate the point that you made. One is where the resident state has the exclusive right to tax. And readily to mind, one can take into account the India-Mauritius treaty, although diluted now, with reference to capital gains, where it says that capital gains arising from sale of shares held in a company resident of the other contracting state shall be taxed only in the state in which the alienator is a resident. So if a Mauritian company sells shares in an Indian company, they are taxable only in Mauritius, this country of residence.
Right.
So the source state where the capital gains arise has actually given up the right. So I don't think you need to go to the article dealing with elimination of double taxation in this kind of scenario, because the right to tax, which is from this particular article dealing with capital gains, is in favor of the resident state. Now, if you look at another converse article where the source state has a right to tax to the exclusion of, again, the resident state, then in that situation, I would take it that the resident state should not tax it, rather than go to the article dealing with elimination of double taxation. And to my mind, what comes in our understanding is, let us say, salary received by crew working on a ship in international waters.
Right.
Now, he may be traveling across the globe in a ship and the family is stationed in India. So the instructions are the salary will be paid into my bank account in India, but he's earned it for services rendered while he's outside India. And he's a non-resident, let us assume, or assume he's a resident here. Now in that situation, will you tax this in India just because it is paid into his bank account in India? To my mind, the answer would be no, because it is for services rendered overseas. And since he has earned it for that purpose, it should not be taxed in India, especially in a case where he is a non-resident. And the treaties have accepted this position, that in that situation, India will not get a right to tax merely because it is received in India.
Yeah, it is a Kolkata traveler's judgment.
Right.
Anyway, because a lot of my friends are in merchant navy, I was in merchant navy before, so this is a very hot topic for
Right.
But we will not go into that. But what Mr. Goel said correctly is basically, normally exemption is provided to if I am a resident of India and if treaties applied in my case, then probably that shall be tax may not arrive, come in many cases, because most of the time India will have a right of tax. So exemption, will only be for the reverse situation. But it can happen like the example I have given earlier, that suppose I go and work with a foreign government for a few days or few months, so that I don't become resident there, I am still a resident of India, and then I get a salary from that government. Now that it will be taxed only in that country. So now that is an exemption method. So India has to eliminate double taxation by not taxing it. But the article on elimination of double taxation in that treaty, particularly in Indian treaty, will say that okay, you will not tax that income, but you will include it for rate purpose. So whatever income I have earned in India, if and that foreign income will get included, average rate of tax will be calculated, and that average rate of tax will be applied on my Indian income. So I will pay tax only on Indian income, but by using that average rate of tax. So that is how even for shall be tax, that article on elimination may have a relevance.
Right. I think both of you agree on that point, that it is possible in the distributive rules also to exclude that income, need not be taken to the article of elimination. So this is time to move to the next one. So this is on the Indian context only, the subsection 2 of section 90. Question is whether the controversy which is there on the navy taxable have arisen because of this section, this provision. So I'll just pick up the relevant phrases of that. Section 90, subsection 2 of the Income Tax Act was inserted in the year 1991, while Finance Act 1991, and has a phrase as follows. I'll just read out that, a portion of that. In relation to the assessee to whom such agreement applies, the provisions of this Act shall apply to the extent they are more beneficial to that assessee.
So there are two interpretations possible. One, the Income Tax Act provisions will apply only when beneficial. Does it mean that otherwise Income Tax Act will not apply at all? The other possible interpretation is that such situations will arise only when we are looking at the taxation of the income of non-resident in the source state.
Section 92, 90 subsection 2 only gives a legislative sanction to that principle. And in Azadi Bachao, the Supreme Court had endorsed that circular 333 issued way back sometime in 1982. So the first point to answer your question, the treaties are as much a part of our domestic legislation because they are entered into in terms of section 90, and as I pointed out to you, section 5 is subject to provision of the Act. So the tax liability of a non-resident is governed by the provision of the Act or the treaty, whichever is more beneficial. Now if the Act is itself providing a beneficial treatment, then you don't need to go to the treaty at all. You need to get into the treaty only if the amount is taxable under the provision of the Act, and then see whether the treaty is more beneficial.
Right. So that means the point which the answer is, so that means when it says to the extent they are more beneficial to that assessee, the provisions of the Act are to apply. So those provisions of the Act include the treaty provisions also, if I'm correct to say.
No, yes, they are, but once there is a treaty, then you need to apply the provision of the Act only to the extent they are more beneficial. To give you an example, for instance, the India-US treaty provided a rate on royalty of 20% in the first 5 years, 15% thereafter. Our domestic rate was lower than the treaty rate. So therefore you could straight away apply the rates under the Income Tax Act rather than going to the treaty.
Yeah, so that is perfectly good example that although USA tax treaty was asking us to withhold 15% tax rate, but because our domestic law was saying 10%, so we could not have exceeded 10%. So that is an example with respect to the non-resident. Probably one doubt may arise with respect to resident, whether this subsection 2 of section 90 equally applies to resident Indians.
Right.
You know, so there probably there is little bit of confusion because when you go through that explanatory memorandum, circulars number, what is that circular? 621, I think. Yeah. So it has used that top headline, you know, when explaining this insertion, taxation of foreign company and other non-resident taxpayers. But when it narrates down under, there, it has not made any distinction between resident and non-resident. So, you know, one can argue that because the headline is that this purpose of insertion of this subsection 2 was to give benefit to non-residents, but a view has been taken by the Supreme Court in Ajay Vohra that probably, you know, it has to apply to all, you know, whichever is more beneficial. And I presume that although you know, revenue may like to argue that it applies to only non-resident. For example, going back to my case of that salary. Suppose in my case, you know, I don't tax that salary income in India. My assessing officer says, sorry, I will not apply 92 to you because you are resident Indian, and he can take help of this headline. But still, I will argue that you know, headline may be non-resident, but if you read the wordings, their intention is that it equally applies to all. And then we have a Supreme Court judgment in the form of Azadi Bachao, which clearly says that whichever is more beneficial to apply.
I think, Vijay, the settled legal principle is on interpretation of statutes, that the heading will not control the interpretation. So if you go by the plain language, it is applicable to all. It is applicable to residents and non-residents alike. And I endorse what Mr. Varshney has mentioned, that you cannot restrict section 90 subsection 2 only to non-residents.
Yeah, that is the general view which is taken. By just looking at 92, there could be a possible other way to look at that, and that could be that this is applicable to the extent they are more beneficial to that assessee. So now the situation will possibly be only when I, being a resident, go to the other state and earn some income there. So my taxation vis-a-vis that country. So a particular income is being earned there. So my taxation is the resident country and the as per the treaty, and the taxation as per the domestic law of that treaty. So comparison has to be there. If we read it in that light, so this stands more consistent actually. There is to the extent they are more beneficial to that assessee. So in case of, that means in the case of non-resident, when I'm going there, I am a non-resident from their side. So in the case of the non-resident, it is being compared that the local law or the treaty which is to be seen. So I have the option to go for the local law of that, or the treaty there. Similarly, when inward, so the situation will apply. So the view which is being raised is it is not applicable to the residents is from that perspective.
No, you see, to a resident, the treaty will apply only when you become a resident of that state. Like, suppose you go overseas and you earn some income, you can claim benefit of the treaty in that country only if you become a resident of that country as per local law of that country.
No. So I am a resident of India, right? I go to XYZ country and I earn income there, so that is to be taxed at source there. So now I am not a resident there, I am just a non-resident for them. I am earning that income, so the taxability of that income is in question.
No, that income will be taxed there according to local laws, but you can't claim the benefit of the treaty.
Now he is claiming the benefit of the treaty because he is a resident of India.
No, he cannot.
He is a resident of India.
No, he is a resident of India, but he can't claim if that income is sourced there.
Yeah.
And if that income at source is to be taxed, then he can't claim the benefit of the treaty here.
So if he goes to Malaysia, so he is claiming benefit of India-Malaysia treaty.
So this is sourced in Malaysia. So now I would look at that.
No, so Indian local law says you have to tax it in India, but the India-Malaysia treaty says it has to be taxed in the country of source.
Source state. So this is our treaty. So that is what I am saying. Because I being a non-resident from their angle, so this is a question.
No, so therefore you can't in Malaysia claim the benefit of the India-Malaysia treaty, no? Even that country, that income is sourced in Malaysia, it must suffer tax in Malaysia only.
But as per the treaty, isn't it?
No, as per the local laws, it is income earned in that state.
But the treaty will come into operation, na? Because if I am an Indian resident and if I go to Malaysia
Right.
and earn an income there,
Right.
so India will say you pay tax because you are a resident of India, so your worldwide income is taxable.
Right.
And Malaysia will say because it is sourced in Malaysia, you pay tax there.
Right.
So we will apply India-Malaysia tax treaty to
No,
decide
we
who will apply.
will get the credit of the tax paid in Malaysia, but how does it become the more beneficial we are on the point whether you can claim the benefit of the India-Malaysia treaty to say which is more beneficial.
No. So the point which I am trying to highlight is, I agree with you. So being a resident, so this comparison will not arise as far as the income in India is concerned. This will arise in the case of when I go out and I am a non-resident here, or take the reverse stage. So the non-resident is coming to India, is earning any income in India. So for them it is a source state. So now the taxability of that income is to be seen. So taxability of that income has to be either by the Income Tax Act or it has to be by the treaty. So what I am saying is that the treaty with the benefit, the comparison will arise only in that situation possible.
No, that is alright. We are looking at whether it can apply to a resident. When we say that the provision of the Act shall apply to the extent they are more beneficial to that assessee. Now if you read that assessee to mean a resident assessee, then we are comparing whether he can claim the benefit of the India-Malaysia treaty in your example. He can't say from a Malaysian standpoint that since this income has suffered tax in Malaysia, I don't pay tax in India. We are only from that point of view.
So what's your view that it can be applicable to resident also?
Yeah, that's my view.
No, it can be,
yeah.
but it will be in certain situations only. And it can be only when you are entitled to the treaty benefit. And if you look at the original article 2 of any treaty, who is entitled to a treaty benefit? Who is a resident of that country, who is liable to pay tax in that country on his worldwide income, not on the income source there, on the worldwide income.
I think we'll move to the next one on this page. Now, on the circular 621 dated 19th December, explaining the provisions in the Finance Act 1991. So, we have already touched upon that. So, the question is it, so it was on the actually retrospectivity. So, what can be the possible position before 1472? So, this is considered to be applicable with effect from that date. So, now, when how do we interpret the applicability? What was the status on that? When this circular was not effective till that date. This is applicable with effect from 1472. The circular 621, which is under we are talking about subsection 290.
But is it relevant now? I mean, basically, 72 or now? I mean, we have already.
I don't know what is the basis for the cutoff of 1972.
Yeah, that is the question. why it is not 261? Why it is not 72?
Yeah, I don't know.
So why this gap has been?
But I mean, it may be of academic interest because as of today, I don't think we are going to face that situation.
Right.
Like
Yeah.
72, somebody of 70 case is going to come up for discussion.
Right.
So, but it is of academic interest. So, from academic point of view, what I feel is that if something is creating a new liability, then if some clarification is creating a new tax liability, then it applies only prospectively. If it is only a procedural matter, then it can go back to the original situation. Then there is another thing, that if circular is a beneficial circular, so if it is a beneficial circular, then what is the intention? Can it apply to all the treaties? Then we have to see the intention of the legislature or the executive central government when they issued the circular. What was the circular? Whether the intention was to apply to all the existing treaties. So if that is there, then it will apply to all the existing treaty, even if they were entered before 72. Because beneficial circular, that is how courts have interpreted it.
Right. I agree with you. It may not be much relevant now. So I think this is the next question is actually the heart of this discussion, and that is the controversy is with on the point of maybe tax. This arose from the decision of the Honorable Supreme Court in the case of PVAL Kulam Dagan Chettiar Supreme Court decision. In this case, the assessee claimed that since he had paid taxes in Malaysia, he was not liable to pay any taxes in India. If he had to pay further taxes in India, there is no question of elimination of double taxation. The Honorable Supreme Court of India accepted Mr. Chettiar's claim and held that he did not have to pay any taxes in India. So now Article 22 of India-Malaysia Treaty makes a clear provision for elimination of double taxation. Point is, this decision is being relied upon in all subsequent cases, and this is the guiding principle which has been set as such. So if you look at the various cases like SRM firm, Turquoise Investment, Pooja Bhatt, SR Oil, Shalini Sikon, which are dealing with this aspect. So, but on the decision where the reliance is being placed, that has not discussed the main article, which is Article 23. It appears that the whole article is reproduced by the Honorable Supreme Court in its decision. However, in the final order, no reference is there to that. So, the question before us is, first question is, can a decision of the Supreme Court be applied automatically without appreciating the facts and the issue on which the decision was given? If no, is the current practice of relying on the decision correct?
See, basically, this is the jurisprudence that has developed in India, that if the treaty uses the phrase may be taxed, it can be taxed only in one of the countries, and that's how you avoid the taxation of the amount either in the source country or the resident country, depending upon the language of the particular article in the treaty. That's a view that the Supreme Court has taken. With respect, that is contrary to the view advocated by international commentators and renowned celebrities who have, written treaties on the rubber tax treaty. The philosophy behind maybe taxes, as was discussed, it is non-exclusive right to both the contracting states, and double taxation may be eliminated by the credit method, by that process of making credit for the tax paid in the source country against the tax payable in the home country on that particular income. But Supreme Court rightly or wrongly took this particular view, and that has been echoed in the succeeding judgments that have followed. But as we discussed subsequently, I think the question is whether this position holds good today post the amendments that have come up in Section 9. For the time being, we'll have to rest it at that since the highest court in the country has laid down this position, this is the law of the land.
I mean, before moving on to that amendment which has come, or the notification that have come, just on this one aspect which Mr. Vohra has commented, I mean, somehow I feel that Supreme Court has not adjudicated on the issue of maybe tax or Article 1 elimination of double taxation. So let us see how it happens. we have a High Court judgment in the case of Muthaiya. Then we had High Court judgment in the case of SRM firm. SRM Muthaiya case maybe tax was not discussed, but SRM firm maybe tax was discussed and it went against us. It went in favor of the taxpayer. Perfectly fine. Then what happened? We did not file SLP in the case of SRM firm. So Supreme Court did not have the opportunity to adjudicate on that issue. Then in Chettiar case, we went to Supreme Court. But and our Attorney General argued everything. He argued maybe tax and he argued article on elimination of double tax, everything he argued. But then Supreme Court somehow, by adjudicating, came to conclusion that he is resident of Malaysia. You know, because he has closer economic ties with Malaysia. And then said because he is resident of Malaysia, so this income is taxable only in Malaysia. There is no PE in India. So and Supreme Court clearly said that we are not discussing maybe tax. You know, there is a clear line written by Supreme Court that we are, because we are holding to be resident of Malaysia and no PE in India, so income taxable only in Malaysia. So it is not required for us to adjudicate on the interpretation of maybe tax. So this is where Supreme Court left it, and they also correctly so did not discuss article on elimination of double taxation. Then what happened that in this what is that finance investment case? What is that? The turquoise investment. So in turquoise investment, once again Supreme Court had an occasion to look into these aspects. That's a very short order. In that order, Supreme Court says that in SRM firm, it was held to be taxable only in one country, and Supreme Court confirmed it in Chettiar case. I mean, the due aspect that actually didn't happen. So basically, we have two Supreme Court cases which have gone in favor of the taxpayer, but in none of them they have examined the issue of maybe tax on an article on elimination of double taxation. And somehow these cases are being echoed because such views have not been presented before subsequent courts. Right. So basically, my view is that even otherwise, even without those amendments, even without those notification, Supreme Court till today has not had an occasion to look into these aspects. And in addition, there is a case of Rameshwar Lal, Sanwar Mal, which clearly says that if something has not been brought out before the Supreme Court, which has not been argued before the apex court, it can have a relook. You know, in that case, although that case went against us, revenue, but in that case, it was a case of HUF, deemed dividend case. So in the same case, Supreme Court had given a judgment in favor of the revenue, and same case for later on, Supreme Court said that just because something was not argued before us would not prevent the taxpayer to argue it now. And then they gave the decision in favor of the taxpayer. You know, so that even if my view is that Supreme Court never argued maybe tax and article on elimination of double taxation. So this can be retried before Supreme Court.
No, I would think that if the issue is to be opened before the Supreme Court, of course, the earlier decision will have persuasive value, but the Supreme Court will definitely have to
Can be distinguished.
Yes, will have to consider the correlation of the expression maybe tax.
Yeah. So moving on to the next one, section 90, subsection 3 provides as in. So any term used but not defined in this act or in the agreement referred to in subsection 1 shall, unless the context otherwise requires and is not inconsistent with the provisions of this act or the agreement, have the same meaning as assigned to it in the notification issued by the central government in the official gazette newspaper. So exercising the power under this subsection, a notification 91 by 2008 was issued regarding baby tax, stating that the foreign income is to be included in the total income and thereafter relief is to be granted. Question 1. Whether the notification is prospective or this can be applied retrospectively.
Yeah, see, my view is, and which has subsequently been tested in two ITAT judgment also, that is because this is not bringing any new liability, it is only clarifying that how credit of the tax is to be given, so it is procedural in nature, so it will apply to the existing treaties. even without insertion of explanation later on, which happened later on, my view is that it will apply to all existing treaties because it is procedural in nature, and this has been considered in two ITT cases, one SROL cases, both ITT Mumbai, SROL cases, and then this Shalini cases, which was just 2 months back. I think that the judgment came here. So in both the cases, in SROL cases, the tribunal said that it will apply from assessment year 4-5 because that was a case of assessment year 4-5. So they said we don't have to go beyond that, whether it will go even beyond that, because that Article 93 was inserted from 1/4/2004. So they said we don't have to go beyond it, whether it will apply to all treaties even before 1/4/2004, but they stopped at that. They said it will apply from assessment year 2004-5, even though it was notified in August 2008. But in Shalini case, they have discussed this and they have said that India-Sri Lanka treaty, although it came into force before 1/4/2004, they'll say it will apply even in for India-Sri Lanka treaty. So that is my view, that it will apply to all existing treaties.
So what do you would? I think this is, according to me, a ticklish question that when you say a term used but not defined, so whether the term may be tax is a term which is not defined in the Act but has been interpreted by the courts in a particular manner. Now, if the courts have taken a particular view on the meaning of the expression may be tax, now whether you can say this is a word that has not been defined and therefore by a notification you can amend unilaterally the interpretation of a treaty. Now, in the context of the amendment in section 9 relating to royalty and all, the courts have taken a view that the legislature cannot unilaterally amend a treaty signed between two sovereign nations. But here, the issue will be that this has never been the international rule, and maybe tax means granting primacy to only one country to the exclusion of the other. It is the courts in India which have taken the view that maybe tax will mean that the income cannot be taxed in India, it can be taxed only in the country of source. Now in that situation, I would think that the taxpayer will have difficulty saying that this amendment cannot be read into from assessment year 2004-5. Now stopping here, the next controversy that will arise is this is an enabling amendment which says that India may subsequently issue a notification. The notification has come in August 2008. Now whether you can relate back the notification to 2004-5 when the legislature took upon itself the power to issue a notification. So whether the amendment should apply or whether this should be read as from 2008 or 2004-5 will be an open question. As Mr. Varshney rightly put it, the tribunals have taken a view that this is to be applicable in the case of SROL from 4-5 itself. Yeah. And it's a very comprehensive judgment that the tribunal has rendered on all aspects of this amendment in section 90 subsection 3 and the issue of the notification.
I think first of all, I fully agree that SROL is a very good judgment and probably it's an opportunity to probably name those few people who were involved. I think Mr. Dastu argued very well from the taxpayer side and my friend Mahesh Ninnuwala argued very well from revenue side, and then this is a judgment by Pramod Kumar ji and it's a very good judgment. I think that covers all aspects. Having said that, I'll just comment on that probably this case is little different from the royalty amendment. Because royalty amendment is something you can say that the other country who was negotiating with India had something else in his mind. But here we can always argue that he didn't have something else in mind.
Internationally, maybe tax has been accepted to mean both countries are right to tax. It is only our Supreme Court which took up.
Yeah, but I agree that this is an issue which probably have to be decided by the courts, and we don't know which side the decision will come.
The other implication of this notification on maybe tax is, so now this has been given in the context of maybe taxed. So there are other terms which are as strong as maybe shall be taxed only. So is it by exclusion that they have just notified this only? Shall we mean that other things are not given the purview of that? So they are okay to go with whatever the jurisprudence is available on that?
No. I think the expression as was originally discussed, they have different shades and different connotations. So intent of having different and varying meanings. So if it is the word used is shall be taxed only, it has a specific definite meaning. Maybe tax will have a completely different meaning and a completely different shade. These words are not interchangeable. These words are not interchangeable.
Yeah, absolutely. And it is only because the controversy arose with respect to maybe tax, different interpretation. Because if you see the enabling section, it says when there is a different interpretation,
Right.
So there have not been interpretation of shall be tax so far.
Right.
So because there is a different interpretation of maybe tax, so government clarified the intention.
Right. It seems to be that there is still a lot of controversy there. The judgment which is given, which is being relied upon in different cases, possibly has not dealt with the issue which we are talking about, and the reliance is being placed by the subsequent judgments on that. So there may be situations when somebody comes up very finely distinguishing it, and court is eager to look into that aspect, and we will have some better jurisprudence on that, more understanding on that, I would say. The purpose of this webcast is to bring out the relevant issues on the subject and help understand the various views and controversies that exist on the subject. To help one evaluate its own, we hope this discussion would have been useful and would have served that purpose. So time to thank our guest panelists and of course the audience. So thank you all for being part of this initiative.
Yeah, I just like to add one thing. Say something in the end. This is I'm sure tax consultant must be facing this problem. I as a tax administrator has faced it. My friend, my batchmate, his son went to UK and earned some income. So he took advice from me. So I said, no, it is maybe tax. You have to pay extra tax here in India. And he paid that tax because I told him that now that we have issued notification, there is no doubt. So he paid the tax in India, and then even after he paid the tax in India, everything, and then came the judgment of Puja Bhatto, Karan Thapar, and then he's after me that see you advise me, and then I'm sure the tax consultant must be feeling this problem. But let me assure everybody that in all those judgments where after the issuance of notification revenue has lost, like Karan Thapar case or Puja Bhatt case, this notification was not argued by us.
Right.
Now it's a different matter. This notification is in the knowledge of everyone, and it is going to be argued by everyone. So it is now clear. After the notification, it is clear that if it is maybe tax, the source country will tax it, but resident country also has a right to tax.
Yeah.
So I would just like to end up with that.
Thank you very much. Thank you.